The Louisiana City Court judge who was caught on camera using the N-word on home surveillance video has resigned. Michelle Odinet initially took a leave of absence after video surfaced showing her and others in her household using the slur while watching surveillance footage of a confrontation with a burglary suspect. In her resignation letter submitted on New Year's Eve, Odinet apologized to the community and asked for forgiveness. Here to talk about this new development and other trending legal matters are former prosecutors Leslie Ricard Chambers and Paul Henderson, who's also BNC's legal contributor. Glad to have both of you with me to talk through this one for sure. Let's start with the former judge's resignation letter to the Louisiana Supreme Court, where she says she takes, quote, full responsibility for the hurtful words used in the video. But did she really? I mean, first she tried to explain this whole thing away by saying her mental state was fragile because of some attempted burglary, which, by the way, the video shows she's anything but fragile. She was actually laughing through the whole ordeal. And she took a sedative at the time of the video that she had zero recollection of using the N-word. She wouldn't believe that explanation, Leslie, if a defendant was using that same lie before her in court. Now, tell me, you are there in Louisiana. What has been the general consensus among the legal community about this whole thing?
The consensus is good riddance. We don't need people like this woman on our judicial benches, particularly here in the South, in the state of Louisiana, where our political relationships and sometimes our racial, some of the racial sensitivities that we have here in our state, you know, those are things that we're still working on. Sometimes those relationships between those two parties and between those various sectors of our communities are fractured. And, you know, and in particular in the town of Lafayette, you know, 61% of the population in Lafayette, Yodit, is Black. 30% or 31% or so are white. But when she ran for office in 2020, she received 56% of the vote. And that's very alarming that we have had someone on our bench in the state of Louisiana who presides over cases where most of the folks that come before her are Black or minorities, and she's using this type of language. And so I don't believe her apology is sincere, particularly when her knee-jerk reaction was to deny it or make some type of excuse for it, and then to suggest that she is not the type of person I guess that she felt that she conformed to, that the language that she used shows that she conformed to. And so no one buys it. And thank goodness that there was so much outcry from all the necessary individuals in our state. Otherwise, I think that she would have kept going if no one called her hand.
Paul, now I'm told that you actually have some connection with this judge. I mean, I know you know everybody, but this judge you actually know?
I actually do know her and knew her fairly well back in the day because we went to law school together, and she was in my law school class. Now that was all the way back in but during the time I knew her because I was president of the class and she was in that class. Now, she was not supportive of my running and my administration while I was there, which doesn't necessarily make her a bad person, but, well, you know, but I did know her back then. And I actually knew her when she went on, because when we both left the law school at Tulane, and by the way, it wasn't a small thing because I was only the second Black president that the law school had in its entire history. So it was kind of a thing at the school when that happened. But then after law school, when we left, we both became prosecutors. I became a prosecutor here on the West Coast. she was a prosecutor along with many of my other friends from New Orleans at the time. And so I did see her and knew her back then. Obviously, I haven't spoken to her in a very long time, and she is presumably in a very different place. And now we have the incident that we have and this apology. And if I can just summarize that apology, I think the apology is sincere in that she was caught, and sincere to the degree that her career is now affected, but it does not go far enough and does not speak to the core of the issue, which is the racial insensitivity. And so the apology that I was expecting, and I think the apology that many of the residents there that had voted for her were expecting, if not the Black and brown communities in that area, wanted her to address directly the social insensitivity, the race disparities, and the inferences about race that were raised from her using the term in the first place. And the apology didn't speak to that, and that's why I'm really frustrated with it. And that's before we start unpacking all of the other issues of the role that she played in the race disparities that we know that go on in our criminal justice, that she played an active role in as a judge. Very disappointing and frustrating.
Now, Leslie, this isn't anything new there in Louisiana. I mean, in fact, in 2003, a 21-year veteran judge attended a Halloween party with his wife wearing an orange prison jumpsuit, a black afro wig, and both he and his wife had blackface. So after a 14-month investigation, the state Supreme Court suspended the judge without pay for a year and a day. In 2020, a judge admitted to using the N-word multiple times in a text exchange with her lover, a sheriff's deputy, in reference to another black deputy and black court clerk. Now, Odinet resigned from the bench, which I don't think she had a choice in that matter, but should she be able to practice law?
And that's a great question, Yodit, because in terms of investigations, as far as those things go for our bench here in Louisiana, the Judiciary Commission could have pursued an investigation similar to what lawyers have to be pursued by the Office of the Disciplinary Counsel here in Louisiana. And so that could have been the start versus her taking some initiative and resigning. But the issue is that she got ahead of it, right? But it doesn't necessarily negate responsibility. The question now is whether or not the Judiciary Council or the Judicial Commission will take the extra step to say and implore to the Office of Disciplinary Counsel, this is someone from the legal community that needs to be looked at a little bit further. And even just to kind of backtrack to some of the points that Paul made about her working as a prosecutor. She was a prosecutor in Orleans Parish back in the 90s, between, I think, 93 and 96, if you will. And that was during the time when Orleans Parish was sending folks to prison all the time, unconsciously, as a matter of fact. And so Jason Williams, the current DA, his civil rights division is looking at the cases that she handled to see if there were any abuses there by this particular judge, and if they were even racially motivated. And so it's got to start, I think, with the office of the DA, which he has taken his own initiative to do. And so if they do find and discover any wrongdoing or any racism or any biases in how she handled her cases, I think that could be prime for any further investigations by the Disciplinary Council to consider whether or not she'll continue to practice law.
Paul, Leslie brought up a point where, the district attorney there in New Orleans, who we've had on the show before, is going to be looking into the cases handled by Odinet. She wasn't just a judge. She was also a former prosecutor there in New Orleans and Lafayette. So we're talking about, reviewing cases, not only of those that she actually presided over. We're talking about her, now reviewing cases where she prosecuted probably hundreds and thousands. What kind of time and resources are we talking about here, and how long are we talking?
We're talking about cases that go back decades now, but that information is information that has to be reviewed and should be reviewed anyway. Let's just be clear about that. And this ties back to the conversation that you were talking about in your first segment about the obligation from prosecutors now to be reviewing their work and looking at it with a new lens, empowered with new technology, with improved DNA information, with improved technology information, to be looking at cases that have a race disparate effect anyway. So they should be doing that process, not just with her cases, but with other cases as well. And that should be taking place all across the country. And if it's not taking place in your own jurisdiction for viewers, this is something that you need to be asking for from the local prosecutors that you have. To me, the more interesting thing, and I'm happy that the prosecution is already reviewing her cases, is the secondary evaluation from her judicial cases, where she was making the decisions about what was going to happen to people. Because in addition to working as a prosecutor, she also worked for a period of time as a public defender, representing people that had been charged with crime. And we already know the race disparate implications from that work as well. So while all of her cases actively as a lawyer are under review, there's a secondary standard for the cases while she served on the bench as a judge. And you hadn't asked this question, but I do think it's important that we talk about, because those standards are for, as a judge, there are 3 different standards of review that we use to evaluate those outcomes in a situation like this. There are questions of law, there are questions of fact, and then there are questions of procedure or of discretion. And it's that third category that I think is under review to challenge or to look at some of the decisions that she had made before, with the standard being either an abuse of discretion or that there is no other way that a judicial officer could have made the findings that she did. And so that's all going on right now, and we'll make a determination as to what happens in her future and whether or not she has a legal future.
All right, we've got more trending legal stories to get into with my lawyers after the break, so stay tuned. You're watching Making the Case. The sentencing phase for the 3 men convicted of murdering Ahmaud Arbery is set for later this week. But the legal battle for William Bryan and the McMichaels is far from over. Still with me is Leslie Ricard Chambers and Paul Henderson to discuss. All right, guys, let's start with sentencing for the McMichaels and William Bryan. All 3 were convicted of murder in the state case back in November, and their convictions carry a mandatory life sentence. So the question is, will they serve life in prison with or without parole? Paul, your thoughts on how the sentencing hearing will go and how the judge may rule?
I think it's more likely that they'll serve sentences without the possibility of parole, just because of the nature of the case and how much pressure I think is going to be put on this judge to hold them fully accountable for their behavior. And keep in mind, what we're going to see as part of that sentencing process is an entire evaluation and a representation from family, from friends, about Ahmaud Arbery in ways that we didn't see during the trial. And I think that's going to create the pressure for the judiciary to hold them accountable in ways that is going to exclude the possibility of parole, to give them the maximum, even though there's not a death penalty at this jurisdiction for the court.
Leslie, your thoughts on what the defense could present as mitigating factors?
I think that the best that they can do is to show that A, they've never been in trouble before, B, to show these the history that particularly the McMichaels had in law enforcement, their relationships in the community, with the law enforcement community. I think that that's the best that they're going to be able to do. And just to add to what Paul said a moment ago as well, talking about those factors, those additional factors that didn't necessarily get brought into the trial as it pertains to the victims, the surviving victims, the family members. We're talking about victim impact statements when you're considering sentencing. And in particular, not just the victims the family members of Ahmaud Arbery, but society as victims as well. These cases that have been tried this past year, including the McMichaels, including uh, Derek Chauvin, including Kim Potter, those cases have established a new precedent in how law enforcement deals with Black and Brown communities, as well as folks who believe that they can act under the color of the law when legally they truly cannot. So those cases just establish a new precedent, and so the victims are also those of us who are potentially in harm's way, if you will, of being put in a position to be victims of these types of crimes, just like Ahmaud Arbery, just like George Floyd, just like Devontae Wright. And so that's something that the court is going to take into consideration as well.
Sentencing in the state case, guys, comes just weeks before the federal hate crimes trial for all three men. Now, they're already convicted murderers, but hate crimes are usually hard to prove, which is why they're hardly prosecuted. Will the state case help in some way, and will this case be difficult for prosecutors, Paul?
It won't be. It will be if the information from the state court will be used in the federal court. And there's such clear indication, even in the arguments from their own lawyers from the state case, on how clearly these individuals and the defendants were motivated by race. And some of the ways, and I won't go into all of them, that were so offensive, clearly to the jury based on their decision, but certainly to the viewers and the audience, and certainly to the court, the decisions that were made in the courtroom on behalf of the defendants and the defendants' own statement were so clear indications of why this case is evaluated as a hate crime in the first place at the federal level. And an interesting twist, some of the issues in the federal level that still exist are they still have the death penalty at the federal level. And certainly those things have been suspended, but that has not been resolved. It has not been removed from absolute consideration at a federal level. And hate crimes is one of the ways that even in a state where you are convicted, if you are charged with a hate crime at a federal level, you are still exposed to the possibility of a death penalty. And so that's in the back of my mind as well. But I'm looking to hear and see how that case gets put in, presuming that none of the defendants do some sort of plea arrangement to just plead to anything to try and do their time federally and do federal custody rather than state and local custody to try and get both death penalty off of the table or remove it from consideration at a federal level, even though they're not enacting it now, and to try and serve their sentence in a federal facility. That's what I'm expecting.
Leslie Ricard Chambers, Paul Henderson, thank you both as always for joining me tonight. Appreciate you.